Right. Anyone else from the council?
Yes. So first of all, the ACLU letter did not say that we could do whatever we want to restrict speech at town council meetings. It said we are... It said the council has a right to set reasonable restrictions on how the open forum period of its meetings is conducted, such as limiting the amount of time people can speak, and certainly can prohibit disruptive behavior. So disruptive is the key word here. That's the key word for this entire motion. And it's interesting that the one motion that will violate constitutional rights is saved for the very end of the meeting at 11 o'clock when half the people have left. As for other towns, so in the summary of this motion, it says other towns such as Exeter. It should say one town, Exeter. It should also say that that ordinance was passed in the middle of September, so it's about 2 weeks old. So there's no feedback, there's no evidence on how things have gone. This is a brand new ordinance in Exeter. Again, one town in Rhode Island. So there's no other towns, there's a town. So what we're seeing here is the kind of thing that you do when you know that you've lost support from the public. Instead of listening to what people have to say, you try to block out all the negative feedback. Instead of taking in and processing different perspectives, you double down by silencing dissent. This is a sort of motion that shouldn't really come as a surprise to people that have been watching these meetings and paying attention. We saw this strategy early on when the council majority voted to move open forum from the beginning of our meetings to the very end, thus making it more difficult for young and old alike to speak their minds. Councilor Mannix lied to the public that night when he said that this would be a temporary move to accommodate for the former town manager's transition. When Councilor Murray and I proposed that we move open forum back to the beginning of the meeting, a few weeks later, the same majority refused. This is the same council president who routinely breaks our official town council rules when he refuses to open first and second ordinance readings to public comment, even though our rules compel the president to open all agenda items to public comment. As many of you listen and watch these meetings know, these are the sort of tactics that are the rule here, not the exception, unfortunately. What I like to do is call the town sergeant up to the podium, if Dave is here. And I don't know if if Chief Corrigan's here. I guess he's not here anymore. All right, Dave, if you don't mind coming up, I have a few questions for you. I think you'll be able to give a little bit of perspective based on your unique position here at the town. So you're the town sergeant, so your position is to keep order, I suppose?
Yes, Jim Manny asked me to take this position 2 years ago, approximately. He says mostly a ceremonial position. It was filled before and it was vacant for a little while. So he said he'd like to get some younger people involved in town council matters. Okay, so you've had this role for about 2 years. Approximately. And you've been to pretty much all the meetings except pretty much? Yeah. Okay. Do you recall how many times an attendee has been removed from a meeting since you've been here? Maybe one time, and not by me. As Jim explained to me, he goes, you have no authority to remove anyone from the meeting, because if that needs to happen, that would be done by a law enforcement official. Okay, so that, as far as you know, that happened one time, possibly? Right. Right. All right. Do you recall, just for being here at the meetings, any instances of threats made with weapons, such as sticks? Not to my knowledge. Okay. Any other weapons? Not to my knowledge. Okay, no physical threats? not to my knowledge.
Okay. I was going to ask this to the chief. He's not here. If you know, that's great. If someone else, Jim, you may actually know from your experience on the force previously. Coming into the building, I didn't see any sort of signage barring firearms at the town hall. So I don't know if you know this or anyone else, but if a person was to possess a concealed carry permit, would they be able to bring a gun into the town hall?
I would say yes.
They would.
And
Okay.
matter of fact, I teach at a high school. It was up until recently where they were allowed to do that in schools until the state revised some of their state laws.
Okay, so that's allowed, but we're discussing banning sticks. All right.
I guess what's the definition of a stick? Popsicle stick? I'm not sure.
All right, cool. All right, thank you, Dave.
All right, I'd like to, could I speak to this matter as a resident?
Sure.
As a resident and also, and I'm not quite sure where this is going, but as you know, most of you know, I'm a teacher at North Kingstown High School. I teach social studies. I've been teaching for over 23 years. I teach US 1 and I teach democracy. Some of you may know it as political science or civics class. And North Kingstown High School was one of the first high schools in the state to mandate that students take civics because we felt it was so important. Currently, as I told you, I teach civics, and I teach US 1 right now. And it's interesting, we're talking about the American Revolution and causes of the American Revolution. And also in that democracy class, civics class that I teach, we cover what the Founding Fathers thought was so important. There's a reason why Amendment 1 is Amendment 1. And it's the right to petition, the right of freedom of speech, and they were willing to die for that cause. And I have a quote here, which I was looking up, and I thought it was appropriate for tonight, if I may. If you give me 1 second. It's from one of my favorite people in history, and matter of fact, it's posted in my classroom. It does not take a majority to prevail, but rather an irate, tireless minority, keen on setting brush fires of freedom in the minds of men. And I think we should remember some of the things that the Founding Fathers did and what they said. And while I don't agree with everything that's said in this meeting, or any meeting, whether it comes from up there or behind me, I do feel it's very important that people get the right to say and think what they believe. Otherwise, we're heading down a direction which none of us would like to head in. So as a personal taxpayer in this town, living here on and off since 1985, and as a history teacher, I would never be in favor of such an amendment or such a rule or regulation in this town. Thank you very much.
Thank you.
All right, thank you, Dave. So a few more questions here. I have a few questions for Solicitor Davis. So, we received that letter from the ACLU. Brings up some issues with freedom of speech, freedom of expression, and the First Amendment, and how this ordinance really puts all that at risk. My first question for you has to do with how this applies to the council itself, as opposed to just the residents out there. So if, for instance, the president of the council refers to audience members as an angry mob, which is a personal attack on a large group of people in the audience, would there be the ability to remove that president at that meeting?
It's not a specific person I'm talking about.
I don't.
It's a personal attack on a group.
I don't know that getting into these hypotheticals would be useful. The point is well taken, and I think it's a slippery slope. And who makes the decisions, and what are the definitions? It's a very hard thing to marshal. I would also like to point out that we do have general rules and procedures for people speaking, and I would suggest that this applies to everybody, although this particular set of rules and procedures, which I think is handed out or posted with the agenda each meeting, in part reads that the citizen shall come forward, state their name and address, and it's asked that each person conducts themselves in an orderly and respectful fashion. And I think that's what the intent here is that I think everyone should be treated, as Jim had said when he was sworn in, everyone should be treated with respect, whether it's the town council speaking to the people that are in attendance or the people up at the podium speaking to the town council. It's got to be mutual respect. I'm not quite sure how you draft around that. I mean, for the most part, these are adults speaking, and we should all know what being respectful is and not making it, you know, personal attacks. You can state your, in my opinion, you can state your position without getting personal. But I don't know, Jesse, it's a slippery slope. I've read the ACLU, I read the Exeter ordinance, and I wouldn't want to be the person making those calls.
Yep, I don't think anyone should. So thank you for that, by the way. I'm assuming, based on your background and also preparation for this item, that you've looked at some case law and precedent. So I want to run through a couple of those with you and just get those out there. And what we're really talking about here is freedom of expression, and that you can really only be removed from public spaces when you're disrupting proceedings. So it's not because you say something that people don't like or you call someone a name. It's the disruption, it's the stopping of the proceedings that, based on precedent, that's what could get people removed. And I can go through some of the cases that show that. So Tinker versus Des Moines Independent Community School District. So 1969, students were wearing armbands in school, and the school was trying to stop that from happening. The Supreme Court held that armbands represented pure speech that is entirely separate from the actions or conduct of those participating in it. The court also held that the students did not lose their First Amendment rights or freedom of speech when they stepped into school property. Just like you don't lose that when you step into the town hall. They said, in our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right of freedom of expression. So even in a limited government forum like a city council meeting, the First Amendment tightly constrains the government's power. Speakers may be removed only if they are actually disruptive. And when you use words like boisterous or personal, it's too subjective and too vague to use in an ordinance. And then we have Cohen versus California, so 1971. This was a court case that was about a sign in a public place that had an expletive in the sign. And the ruling was that states must have a better reason than a concern for generally disturbing the peace when they ban displaying an expletive in public space. So they can't just be concerned that it's going to disturb. It has to actually happen and be disruptive and disturb. And then we have White versus the city of Norwalk. That's 1990. So we're moving closer in time. So this has to do with a member of the audience at city hall meetings being removed. So extremely relevant. So the point at which speech becomes unduly repetitious or largely irrelevant is not mathematically determinable. The role of a moderator involves a great deal of discrepancy. Undoubtedly, abuses can occur, as when a moderator rules speech out of order simply because he disagrees with it, or because it employs words he does not like. Speakers are subject to restriction only when their speech disrupts, disturbs, or otherwise impedes the orderly conduct of council meetings. So again, we're seeing the trend here, that it's actually based on time and disruption and stopping the meeting. It's not just because someone says something you don't like. I'll be wrapping up. I do have one more court case. Kind versus Santa Monica Rent Control, 1995. We upheld a spectator's ejection from a public meeting only, and that's the key word, only because he was disrupting the proceedings by yelling and trying to speak when it was not time for discussion. So that would be like if someone stood up in the middle of our meeting and disrupted, which is not what this ordinance pretends to do. So with all that said, I have a statement that's really for you because you're the one who's going to be directed to do this if it passes. But I do hope that you, Mr. Davis, will honor the oath you took to support the Constitution of the United States and the Rhode Island Constitution and stand up for the people of Narragansett by declining to draft this unconstitutional ordinance if the motion passes tonight. This council and this town looks to you for counsel and relies on your integrity and expertise. We hope that you'll do what's right and not just what you're directed to do, no matter the consequences. Thank you.
Stand up for